All right. This hearing of the Committee on the Judiciary, Subcommittee on Commercial Administrative Law will now come to order. Without objection, the Chair will be authorized to declare a recess of this hearing. I'll now recognize myself for a short statement. Today we examine the conditional dischargeability of student loan debt in bankruptcy, with a particular emphasis on the discharge of private, non-federally guaranteed or subsidized student loans. Congress has not held a hearing on the student loan dischargeability provision of the Bankruptcy Code since its first enactment in 1976, which was an amendment to the Higher Education Act, nor has it considered the 2005 extension of this provision to private student loans in particular. In light of the rising cost of obtaining higher education, and particularly in light of the increase in the relatively unregulated private student loan market, such an examination is long overdue. We both see these higher cost of higher education and people having more difficulty securing second jobs and whatever necessary to help them through college, and then a difficulty in getting jobs once they're out to use their education. Unlike other kinds of unsecured debt, the Bankruptcy Code conditions the discharge of student loan debt on a debtor showing that he or she will suffer an undue hardship if forced to repay the loan. Congress's rationale, if there is such a thing, for giving student loan creditors favorable treatment in bankruptcy was to protect the viability of the federal student loan program and, more generally, public monies. 4 years ago, Congress went beyond federal money protection and extended this type of favorable, unusual treatment to a private student loan without any rationale expressed or claimed, no empirical evidence supporting such an extension. It's understandable why we want to have some level of support for our own loan program, but for those less favorably offered privates, there was no particular reason, except that BAPCISA in 2005 kind of took in the entire sink of what people desired to have in the law, and that's what happened. Access to education has been one of the defining issues of my legislative career, which has lasted now through 3 decades. As a Tennessee senator, I fought 18 years to establish the Tennessee Lottery, which provides Hope scholarships, as in Georgia, to young people who meet certain criteria and gives them scholarships over $1.5 billion worth thus far since the program was initiated in 2004. These scholarships have done a lot for students in Tennessee, but they need other monies as well to make it through college. And the scholarships we have in Tennessee, the Hope scholarships, help folks make it who otherwise might not be able to afford it. And there's a merit portion and a need-based portion. Given this history of championing access to higher education of students of modest means, I view with concern the great increase in the number of private student loans issued over the last decade. Ostensibly, these types of loans, which are not federal guaranteed or subsidized, could provide greater access to a college education for those who may not qualify for federal loans or who would otherwise not be able to afford college education. However, recent studies suggest that the access that private student loans could provide may bring costs that outweigh their benefits. Private student loan borrowers often find themselves trapped under the weight of tens of thousands of dollars in expensive, high-interest, high-fee student loan debt with no guaranteed opportunity for income-based repayment, deferment, or forbearance. It was these type of loans that caused me to condition Tennessee's lottery program on repaying college debt, where I'd seen too many people in my private practice who had high debt and had one foot in bankruptcy while struggling to get their debt paid off, which would never have come to an end. Unlike federal student loans, private loans lack consumer protections and any hope of having a job later, leaving financially distressed borrowers with little option but to seek bankruptcy relief. Some commentators have suggested that such bankruptcy relief may be too difficult to obtain, or at least that obtaining discharge may be haphazard. Professor Rafael Pardo, one of our witnesses today, has conducted empirical studies suggesting that similarly situated student loan debtors may receive different outcomes with respect to their attempts to discharge student loan debt. Non-legal factors such as the experience level of the debtor's attorney or the identity of the judge often determine the outcome of the discharge request, raising questions about whether the undue hardship standard is really a workable one. Kind of reminds me of Barry Scheck yesterday. I thank our witnesses for being here today, and I look forward to their testimony and maybe seeing why these student loans are put in a special category, otherwise reserved for things like fraud, child support, alimony, and primary home mortgages. I now recognize my colleague, Mr. Franks, the distinguished ranking member of the subcommittee, who has offered to forego this hearing, but his offer was not accepted for his opening remarks.
Well, thank you, Mr. Chairman. Mr. Chairman, last week, on a largely party line vote, the House in full session passed H.R. 3221, the Student Aid and Fiscal Responsibility Act. The fiscal responsibility part confuses me, but will be that as it may. This legislation is a dramatic shift away from private student lending and toward consolidation of federal power over higher education financing. In fact, today, according to the Time magazine, the administration's proposal to restructure the student loan industry is, according to them, much closer to an actual government takeover than its health care reform plan. The passage of H.R. 3221 in the House makes today's hearing, in my judgment, especially troubling. If H.R. 3221 isn't the death knell of private student lending, ending the favorable treatment that private student loans receive under the Bankruptcy Code certainly could be. Since 1976, Congress has gradually increased the protections that federal nonprofit and for-profit student lenders receive under the Bankruptcy Code. Some would like to see these bankruptcy protections erased, especially with regard to privately issued student loans. However, Mr. Chairman, privately issued student loans increase access to education by providing a source of funding to those that need to borrow more than the federal student loan limits allow. Additionally, private issued student loans allow lenders to tap into billions of dollars in private capital. Now, private capital, maybe we should toss in here just the definition. Private capital is that capital that the federal government doesn't have to borrow from abroad to fund our nation's educational system. Critics of the special bankruptcy protection student loans that student loans receive point to the high costs of higher education that lead many students to incur substantial debt as they try to put themselves through school, and I understand that. But college affordability and the cost of student loans are issues Congress should indeed try to address. But allowing student loans to be unconditionally dischargeable in bankruptcy is not a solution to those problems. If we make student loans unconditionally dischargeable, we will encourage abuse, increase the interest rates students pay on their loans, and dry up the flow of capital into the student lending market. This will either decrease access to higher education or create a vacuum the federal government will have to fill, again, at taxpayer expense. Now, I suspect, of course, that the push to make privately issued student loans unconditionally dischargeable is part of a broader effort to replace all privately issued student loans with government loans. But, Mr. Chairman, just as we do not need a single-payer health care system, we do not need a single lender higher education system. There is no reason to crowd private lenders out of the student loan market, either directly through legislation like H.R. 3221 or indirectly through changing the bankruptcy rules that apply to student loans. Yes, Mr. Chairman, the government should regulate private student loans to eliminate any abusive lender practices. But the real culprit here is the rapidly rising cost of higher education, which has been escalating way beyond the general rate of inflation. Making private sector loans dischargeable in bankruptcy will do nothing to solve college affordability problems. And ultimately, Mr. Chairman, I like to say sometimes that future generations are watching, because I truly believe that in the long run, when we as government come in and try to think that somehow our power can repeal the laws of mathematics and make private lenders just suddenly do the same thing that they've always been doing, even though that there's greater risk to them, it just doesn't happen that way. And I know it's a good theory, but someone said that there's nothing more tragic in this world than a beautiful theory that's totally destroyed by an unruly set of facts. And unfortunately, the effect of both this legislation that we've discussed and this bankruptcy concept that we're discussing will be to drive capital away from the ability to help finance education. And I believe that that will hurt students in the long run. And unfortunately, Congress doesn't have the power to do anything to repeal that mathematical equation except to inject taxpayer dollars into the equation, and sooner or later there will be a day of reckoning. I submit that it's probably already here. We don't know it. With that, I look forward to the witness's testimony and yield back the balance of my time. Thank you, Mr. Chairman.
Thank you. I thank the gentleman for his statement and for looking forward to the witness's testimony. I now recognize Mr. Conyers, the distinguished member of the subcommittee, for his opening statement, and the chairman of the Committee on the Judiciary. Do you have an opening statement, or would you like to waive?
Well, I'll partially waive it, Mr. Chairman. Just to greet Danny Davis and to commend him for the great work that he's done in the course of his career. I mean, it's not anybody that can get President Bush to sign a bill that we thought he didn't like. and there we were in the White House up there with President George W. Bush, just like it was normal way we do business around here. So I commend him for his tenacity. I knew Danny Davis when he wasn't a congressman, and I think that this idea is very important. And the reason I only need a minute is that I've started thinking about what is so different about discharging student loans that's different from discharging everything else that's dischargeable. I mean, this isn't a gambling debt. This isn't something that's against the common good or against the general welfare. Credit cards are dischargeable. I don't hear anybody ranting about that.
I'll rant about it if you want.
You rant about it too. You rant, okay, well, that's good. Consistency is the hobgoblin of great minds.
Keeping in mind the undue hardship.
And what about mortgages being discharged in bankruptcy? You can, your yacht is dischargeable in bankruptcy. Your vacation resort or place is dischargeable in bankruptcy. Your second or third home are all dischargeable in bankruptcy. But then you get to, what are these people doing trying to get an education and run into trouble, and they go to the bankruptcy judge? Well, no, the door's closed. After all, in 1976, we said enough of this government-funded, guaranteed student loans being made dischargeable. We're changing that. Well, my colleagues weren't even here in 1976, so I can't even blame them for it. Matter of fact, they could blame me for it. I was here. So I think Congressman Davis asking us to take another look at this is a good idea. I'll put my statement in the record.
Thank you, Mr. Chairman. I appreciate your statement, and don't hold you responsible for the other 434 people in 1976. Without objection, other members' opening statements will be included in the record. I'd like to thank all the witnesses for participating in today's hearing. Without objection, your written statements will be placed in the record. And before we go into all that, I'd like to introduce our first panel, which is a singular panel, Congressman Danny Davis, who's been introduced already to some extent by the chairman and in a way beyond what I could do to recognize him. He represents the 7th Congressional District of Illinois. Currently, Representative Davis serves on the Committee on Ways and Means and the Committee on Oversight and Government Reform. He's a member of the Congressional Black Caucus, co-chairman of the Community Health Centers Caucus, co-chairman of the Congressional Sugar Caucus, and the Progressive Caucus. And a man I'm fortunate to serve with and know as congressman. And I look forward to the day that I know him as something else. Thank you, Mr. Davis, and you may begin your testimony.
Thank you very much, Chairman Cohen, Ranking Member Franks, Chairman Conyers, Mr. Watt, Mr. Campbell, Mr. Coble, all the members of the committee. I thank you for holding this hearing to examine the hardships associated with the inability to discharge one's private educational debt via bankruptcy. As a co-chair of the Community Reinvestment Task Force within the Congressional Black Caucus, I thank you for the opportunity to voice the concerns of the task force members about the hardships associated with the non-dischargeability of these debts and the likely disproportionate effect of this policy on African Americans. Two studies released in August raised concerns for the members of CBC's Community Reinvestment Task Force with regard to the bankruptcy protections afforded to private educational debt. A study by the Project on Student Debt found a dramatic increase in the use of private student loans and that African American students were statistically more likely than other students to borrow such loans, with the percentage of African American private loan borrowers quadrupling from 4% to 17% in the last 4 years. In addition, an analysis by Moody's Investment Service found that private loans made directly to students tend to have higher default rates. Together, these reports indicate that tens of thousands of students, and especially African American students, are relying on private, non-federal educational loans that lack basic consumer protections and that receive statutory protection from bankruptcy except under extreme circumstances, making these borrowers much more likely to experience financial hardship associated with private educational debt. In addition to these studies, I have many personal stories from borrowers who bettered themselves via education, only to experience tremendous economic hardship associated with their private student loans, including Mandy from Illinois and Laura from Ohio. Shockingly, one lender's representative jokingly suggested that Laura and her husband could sell their kidneys to help pay off the loans. The hardships associated with these debts and our bankruptcy policies are neither funny nor simply business. They are significant burdens to our citizens. Our concerns over the privilege afforded to private education lenders are heightened by data last week showing that racial disparities in lending exist, even for high-income borrowers earning over $100,000. As policymakers, we want to ensure that our statutes do not unintentionally burden particular groups of people. Private education debt is no different than any other consumer debt. It involves private profit and deserves no privileged treatment. The members of the Community Reinvestment Task Force are concerned that current bankruptcy law penalizes borrowers for pursuing higher education, provides no incentive to private lenders to lend responsibly, and possibly affects African American borrowers more negatively than borrowers from other racial and ethnic groups. And so, Mr. Chairman, again, I want to thank you and members of the committee for the opportunity to be here to share these concerns and to testify before the committee. I thank you very much and yield back the balance of my time.
I want to thank Congressman Davis for his testimony and for his amendment he offered last year that I was happy to support and glad to support. Are there any questions of any members of the panel for Congressman Davis?
Could I just thank Congressman Davis for being here? Notwithstanding in my earlier comments, I certainly laud your commitment to trying to do things that are motivated from the right point of view, and I thank you very much for being here, sir.
And I thank you very much, Mr. Franks, for your comments.
Thank you, sir. I appreciate your bringing this issue to my attention last year with your timely amendment that was unfortunately not successful, and your continued persistence. appreciate your opening statement. It looks like you're making some headway with my distinguished and a great mind ranking member, and so I think we'll be working with the staff to try to bring some legislation. Hopefully it can be bipartisan, and if not, we'll just have to try to forge ahead and do what's right. And with that, we thank you, and you're dismissed, relieved, and allowed to vote, which we will soon join you. We've got a vote in 15 minutes. I don't know if it's worth trying to start the second panel. We've got a second panel. We can try at least one witness. We'll go. So second panel, come on up. We'll get started.
13 minutes allowed.
All right. 13 minutes for vote. So maybe we can get through at least one witness, maybe two. And we appreciate your being here. Thank all the witnesses for participating in today's hearing. Without objection, your written statement will be placed on the record, and we'd like to ask you to limit your remarks to 5 minutes. You got a lighting system in front of you. You got a button to push to turn your microphone on. Light comes on green. That means you're between 5 and 1 minute. You're into your speech of 5 minutes, and you've got at least more than 1 minute left. Your yellow light means you're in the last minute, and red means you're supposed to finish and allow us to move on. After you present your testimony, subcommittee members will be permitted to ask questions. Again, the 5-minute rule. And our first witness today will be Lauren Asher. Lauren Asher, a nationally recognized expert on student loans and financial aid, with a very pleasant smile. Ms. Asher is president of the Institute for College Access and Success, an independent nonprofit organization working to make higher education more affordable and available for people of all backgrounds. The Institute is home to the Project on Student Debt, which Ms. Asher helped found in 2005. After serving in senior positions to the Kaiser Family Foundation, National Partnership for Women and Families, and U.S. Department of Labor, she founded and ran Asher Policy Consulting from 2002 to 2005. Her clients included foundations, national, state, and local nonprofits working to improve the lives of children, youth, and working families. With such a background, you're like Betty Crocker, I guess. Thank you for being here, Ms. Asher, and you may begin your testimony.
Thank you, Chairman Conyers.
Punch your button.
Oh. Can you hear me?
We can hear you, and your green light is on, which means you're running.
Thank you. Thank you, Chairman Conyers, Chairman Cohen, Ranking Member Franks, and all the other members of the subcommittee. I'll skip my introduction since you've done it for me. Post-secondary education is increasingly essential to both the future of our nation and to individual Americans who seek to enter or remain in the middle class. However, as college costs have outpaced family incomes and available aid, more Americans have had to borrow for their education than ever before. 2/3 of all students who graduate from four-year colleges now have student loan debt. Most have federal student loans, but a growing number have private student loans as well or instead. Last year, 1/3 of all bachelor's degree recipients used a private student loan at some point before they graduated. Private student loans are one of the riskiest ways to pay for college. They are expensive, mostly variable rate loans that cost more for those who can least afford them. Private loans do not have the fixed rates, consumer protections, or flexible repayment options of federal loans. They are not guaranteed by the federal government, are not part of the federal student loan program, and are not financial aid any more than using a credit card to pay for tuition or books is financial aid. Yet
Don't worry about Beulah. Go ahead.
Yet despite how similar private loans are to credit cards and other consumer debt, since 2005 they've been treated very differently in bankruptcy. The 2005 bankruptcy reforms also made it significantly more difficult for anyone to declare bankruptcy, while changing the treatment of private student loans as well. Today, credit cards and other forms of consumer debt, even gambling debts, are dischargeable in bankruptcy, but private loans are non-dischargeable along with federal student loans, back taxes, child support, and criminal fines. Borrowers who have already met the stringent test for bankruptcy must initiate a separate legal proceeding to prove to a judge that repaying their private student loans would create an undue hardship. As other witnesses will testify today, without a high-priced attorney, this is virtually impossible to do. And even then, the outcomes depend more on arbitrary factors like the judge before you than the merits of your case. There are reasonable arguments for making federal student loans at least somewhat harder to discharge in bankruptcy, although not necessarily as hard as criminal fines. For example, federal loans are backed by taxpayer dollars. They offer some significant relief in situations of economic hardship, unemployment, death, disability, as well as payment plans like income-based repayment that can help borrowers meet their obligations and avoid default in bankruptcy. Private student loans have none of these benefits in our commercial products. There's simply no justification for putting them in the same category as federal loans in bankruptcy. Giving the private student loan industry privileged treatment in bankruptcy is particularly inappropriate. Its predatory practices have targeted young people who have no financial experience with deceptive marketing, high-pressure sales tactics, and kickbacks to colleges for steering students to these high-priced loans. Until Congress passed legislation last year, there were virtually no regulations to limit the dangers of private student loans. Prospective borrowers were not even entitled to information about the actual loan terms and costs before they had to sign the promissory note. Even today, private loans remain largely unregulated, and the new congressionally mandated disclosure requirements don't go into effect until next year. Students and families should be able to count on their college financial aid offices for impartial advice about loans and lenders, and most can. However, over the past few years, federal, state, and independent investigations have exposed numerous conflicts of interest. College officials received gifts, trips, stock options, and other benefits from lenders. Some colleges agreed to recommend a lender for kickbacks on the loan proceeds. In other cases, lenders staffed call centers and financial aid offices, posing as college representatives while giving very biased advice about student loans. Legislation passed in 2008 was aimed at curbing such abuses, but did nothing to help the unsuspecting students already saddled with these costly loans. Shielding private loans from bankruptcy means that unaffordable repayment demands can extend literally forever, even after death. It may also make lenders less cautious about making loans to people who cannot afford them, such as low-income students at schools with low completion rates and job placement rates. From 2006 to 2008, Sallie Mae increased its non-traditional subprime lending to students by 42%. As default rates soared and the financial markets collapsed in 2008, Sallie Mae stopped making these loans, but thousands of American students were stuck with this high-cost debt. In a particularly disturbing development recently revealed in the AP story, some large for-profit colleges have started making their own private loans directly to the same high-risk students. For example, Corinthian Colleges plans to make $130 million of such loans this year alone, made $120 million last year, while telling investors that it expects nearly 60%, that's 60%, of borrowers to default. Ironically, private lenders remain fully eligible for the bankruptcy protection that their borrowers are now denied. The Education Resources Institute, Education Finance Partners, and My Rich Uncle all recently declared bankruptcy. They were able to make a fresh start regardless of why they failed. Their borrowers deserve the same fair treatment in bankruptcy. Thank you for inviting me to testify today, and I welcome your questions.
Thank you, Ms. Asher. We appreciate your testimony. I now have the august power, which I announced at the beginning, to declare a recess of this hearing of any time I please. If you notice, my two colleagues urged me to start the panel. They've left. I need now to vote. The hearing is recessed. We'll be back. Are you related to Don Pardo?
No, but everyone asks.
I didn't want to be different. Not that I'm not. How many years were you in New Orleans? We don't have to.
I'm sorry? I got there in basically summer of 2003 and left in July of 2006. In fall of 05. So I did. I had about 2.5 feet of flooding in my house. It was pretty remarkable. And I got to spend the fall semester in South Carolina, where my wife's family is from. The entire university shut down for a semester. And then we returned in the spring semester to finish off. I'm sorry? Yes. No, I don't believe it did. Yeah. Yes. No, by definition they can't, since they don't have a football team. It could.
Okay. With the august power that I have, we are now back in session. Mr. Conyers, I think, will be here in a second, and Mr. Franks will be maybe back hopefully soon. He has another hearing. So we thank Ms. Asher for her testimony, and now we will recognize Mr. Rafael Pardo, who's a tenured member of the faculty at Seattle University School of Law, which does not have a football team, and where he went to in July of 2006. Prior to that, he was an associate professor of Tulane Law School, 03 to 06, routinely teaches courses in bankruptcy and commercial law. Most of his research is focused on the discharge of student loans in bankruptcy, and he's been published in the American Bankruptcy Law Journal, the Florida State University Law Review, and the University of Cincinnati Law Review. Before entering academia, he worked as an associate in the business reorganization and restructuring group of Wilkie, Farr, and Gallagher in New York. With that, we welcome Professor Pardo, and you may begin your testimony.
Chairman Cohen, Ranking Member Franks, Chairman Conyers, and other members of the subcommittee, it is my great privilege and honor to testify today on the discharge of student loans in bankruptcy. Much of my academic research studies this process, and with each study I have conducted, I have become increasingly convinced that the process is horribly broken and in desperate need of reform. I want to begin today by providing some historical perspective on the treatment of educational debt in bankruptcy. That perspective underscores that we have reached the point where we are today as a result of interest group-driven legislation rather than sound policy choices. Currently, a debtor may discharge student loans in bankruptcy only upon establishing that repaying such loans would impose an undue hardship, but this has not always been the case. Prior to 1977, student loans were automatically discharged in bankruptcy. Perceived abuse of the bankruptcy system, as opposed to any real abuse, drove Congress to change the state of affairs. A 1976 GAO report had found that less than 1% of all federally insured and guaranteed educational loans were discharged in bankruptcy. In other words, no abuse. What did exist at the time were isolated instances of bankruptcy filings by recent graduates on the eve of lucrative careers. These stories were sensationalized by student loan industry advocates and used to prompt Congress into legislating against alleged widespread abuse that did not exist. Simply put, a few bad apples spoiled the barrel rotten for everyone. Over the past 3 decades, Congress has repeatedly curtailed the bankruptcy relief available to student loan debtors. In every instance that it has done so, there has never been, to my knowledge, any empirical evidence presented to demonstrate either real threats to the fiscal solvency of student loan programs or abuse of the bankruptcy system by student loan debtors. The most recent change occurred with the 2005 amendments to the Bankruptcy Code. By virtue of that legislation, for-profit student loan lenders have been extended the special treatment that had been reserved up to that point in time for governmental and nonprofit student loan lenders. This change did not meet with any objections from lawmakers, even from the House members who expressed dissenting views to accompany the House Judiciary Committee's report on the 2005 amendments. This episode strikes me as one of the most emblematic instances of the student loan lobby's excessive influence on the design of the Bankruptcy Code's student loan discharge provision. The upshot of the historical record is that the plight of bankruptcy debtors who seek a discharge of their student loans has become worse, and this has occurred without legitimate justification. I am therefore greatly encouraged that the subcommittee is re-examining whether to undo the special treatment that exists in bankruptcy for private student loan lenders. In the written testimony I have submitted to the subcommittee, I make 4 major points. First, Empirical evidence suggests that student loan debtors suffer from severe financial distress, more so than debtors in the general bankruptcy population. In one of my studies, I found that the median debtor who sought a discharge of student loans was 42 years old and would have had to devote 2 years and 9 months of household income to fully repay those loans, assuming during this period of time that the debtor's household could live expense-free and that the educational debt would not balloon by virtue of interest, fees, and the like. This is a crushing debt burden, plain and simple. Second, the undue hardship standard for discharging educational debt is currently undefined by the Bankruptcy Code. As such, the standard provides minimal guidance to litigants and judges. My studies have shown that this produces differential treatment of similarly situated debtors, with some granted a discharge and others denied a discharge. Third, one of my studies demonstrates that legally irrelevant factors, such as the level of experience of the debtor's attorney and the identity of the judge assigned to the debtor's case, seemingly affect whether a debtor obtains a discharge of his or her student loans. This raises important access to justice concerns. Fourth, private student loans are largely unregulated. Borrowers of such loans often find themselves deeply mired in debt with limited options for repayment relief. When Congress removed the automatically dischargeable status of private student loans in bankruptcy, it stripped away the social safety net available to borrowers of such loans. In the absence of robust non-bankruptcy relief from private student loans, the negative effects of litigating claims of undue hardship will fall disproportionately on debtors with such loans. In terms of solutions, I respectfully urge Congress to restrike the balance between student loan debtors and lenders of private student loans by making such loans once again automatically dischargeable in bankruptcy. I would also urge Congress to clarify the undue hardship standard. The simple solution would be to create a statutory presumption of undue hardship when a debtor does not have enough disposable income to make his or her student loan repayments. An analogous presumption already exists as part of the process for approving reaffirmation agreements in bankruptcy. Writing a similar presumption into the Bankruptcy Code's undue hardship discharge provision would strike a more appropriate balance in a litigation process that unjustifiably favors student loan creditors who undoubtedly have more resources than their debtor adversaries and who have more familiarity with the bankruptcy system as repeat players. These proposed solutions are important first steps to restoring consistency in our higher education finance system, which currently has a public-oriented approach to student loan origination, but a business-oriented approach to student loan collection. This concludes my testimony. Thank you again for providing me the opportunity to testify before you today. I look forward to answering your questions.
Thank you, Professor Pardo. Appreciate your testimony. Our third witness is Doug Cuthbertson.
Yes, sir.
Mr. Cuthbertson is a member of Miles and Stockbridge, commercial and business litigation practice in Northern Virginia. He practices in the areas of commercial law and contracts, consumer financial services, business torts, intellectual property, and bankruptcy litigation, real estate, and creditors' rights. His represents secured and unsecured creditors in adversary proceedings and contested matters in bankruptcy cases. He also represents financial institutions in consumer financial services litigations in the federal system. Thank you for being here with us today, Mr. Cuthbertson, and we will now recognize you for your testimony.
Thank you, Chairman Cohen. Chairman Conyers, Ranking Member Franks, other members of the subcommittee, thank you for inviting me to testify before you today. I've been asked to appear to testify as to the effectiveness of the undue hardship discharge provision as it currently exists in the Bankruptcy Code. My testimony is that of an attorney. I'm not here representing a client or my firm. The exception to the discharge for educational loans was enacted in 1976, and the reason that it was enacted was in response to a flood of student loan bankruptcies in which debtors were filing for bankruptcy based almost solely on student loan debt. The non-dischargeability provision had two goals: to maintain the financial integrity of the student loan system and to curb abuses by recent graduates who have their whole earning lives of earning capacity ahead of them. One reason that the exception to discharge is particularly important for educational lenders in both the federal and the private system is the underwriting criteria that the lenders use. Historically, private educational lenders have only regarded a student's future capacity to repay. That's in stark contrast to other types of commercial and business loans that are made in the private sector, where debtors will generally regard a host of factors, including current ability to repay, credit history, future ability to repay, the value of any collateral securing the loan. None of those considerations are present in educational loans. The congressional purposes of maintaining the financial integrity of the student loan system as well as curbing abuses of the system, apply equally to federal loans as well as to private loans. And Congress implicitly recognized this in the 2005 BAP-CIPA amendments when it amended Section 523A8 to include qualified educational loans. That includes most private loans. So Congress has treated them both the same. And it's important to recognize, I think, that private loans supplement the federal loans. They're meant to be a supplement to cover the rising college costs, and they are rising rapidly. And so private loans have become an important source of additional funding for education for students. Without the undue hardship standard, borrowers could enjoy the benefits of their education without having to repay their loans, without even attempting to repay their loans, by filing for bankruptcy immediately upon graduation. In the private sector, private loan industry, there is concern that this would lead to one of three consequences. First, the private loans would no longer be made. Private sector lenders would no longer make private educational loans. They could also require a cosigner or tighten up credit granting criteria. And then the third concern that has been expressed to me is that students would simply use private loans instead of federal loans, knowing that they are fully dischargeable immediately upon graduation. Congress has not defined the term undue hardship, which has led to judicial interpretation of that term and reliance on case law. The grounds generally include illness, incapacity, extraordinary or unique circumstances like total permanent disability, provision for dependent children, etc. But it's important to note that since it was not defined in the code, the case law has developed, a well-developed body of case law, frankly, has developed, and the inquiry is very factually intensive, and it requires a trier of fact to make these determinations. The bankruptcy judges here, who are the triers of fact, are in the best position to evaluate the circumstances of each particular debtor's case. The standard works relatively well, but I will say because of the factually intensive nature of the inquiry, there will be more compelling stories, where students have not received a discharge. Equally, there will be compelling stories where they have. So it varies on a case-by-case basis, but that's the only way it can in our system of litigation. I would also point out that bankruptcy is a last recourse for debtors. There are certain other administrative benefits that they can avail themselves of to mitigate student loan debt. Chairman Cohen, Representative Franks, thank you for the opportunity to testify before you today. I'll be happy to answer your questions.
Thank you, Mr. Cuthbertson. I appreciate your testimony. Our final witness, our cleanup batter, is Brett Weiss. Mr. Weiss currently heads the Bankruptcy and Insolvency Group at Joseph, Greenwald, and Lake. He has experience in all the chapters, 11, 13, and 7, and he's represented individual and corporate debtors and creditors in all phases of bankruptcy. We thank you for your willingness to testify, and would you begin your testimony?
Thank you, Mr. Chairman and members of the subcommittee. Good afternoon. I'm Brett Weiss, a bankruptcy attorney from Greenbelt, Maryland. I appear today on behalf of the National Association of Consumer Bankruptcy Attorneys, NACBA, and the National Consumer Law Center, NCLC. NACBA is the only national organization dedicated to serving the needs of consumer bankruptcy attorneys and protecting the rights of consumer debtors in bankruptcy. The nonprofit NCLC specializes in consumer issues and has established the Student Loan Borrower Assistance Project, which provides information about student loan rights and responsibilities. I appreciate the opportunity to speak with you about an issue I deal with on a daily basis, the harsh treatment of student loans in bankruptcy. Most Americans see a college degree as the single most important factor for financial success and a place in the middle class. But with skyrocketing tuition and related expenses, more and more students are forced to turn to loans to pay for that education. I have 3 teenage daughters. One is a college freshman, another a high school senior, and a third is in her last year of middle school. I can't afford out-of-state tuition and costs for all three, over $120,000 each for 4 years. And that isn't even for a top-tier college, where those expenses can easily run $50,000 a year, $200,000 at the time of graduation. 2/3 of all college students borrow money to pay for college, and due to high tuition and low federal loan caps, an increasing number take out private student loans. What borrowers are finding is that there's no margin of error when it comes to student loans. Students who choose public service or other low-paying careers, or whose education doesn't provide the opportunities they expected, too often begin their adult lives with student loans they can't pay, creating a financial black hole from which they may never emerge. I see these people in my office every day, and since the 2005 bankruptcy law gave private student loans the preferential treatment previously reserved for government-guaranteed student loans, there's little I can do to help. These loans are not dischargeable except under very extreme circumstances, and even there is a very high cost for them to be able to pay an attorney to represent them in the protracted litigation that Mr. Cuthbertson referred to. Private student loans are huge profit centers for lenders, while students often find themselves loaded with high interest rates and mountains of debt. Indeed, interest rates and fees on private loans can be as high as those on credit cards. And unlike federal student loans, there's no limit on the size of the private loan and minimal regulation of their terms and costs. Like other private loans, private student loans are made and priced based on risk. There is simply no public policy justification to treat this one type of private loan differently by denying a discharge solely because of how the money is used. The discharge is a fundamental purpose of individual bankruptcy, providing the unfortunate but honest debtor an important fresh start. Exceptions to discharge should be carefully considered and adopted only when necessary to further other important policies. Because private student loans are usually made at market rates and on the same basis as other loans, we see no reason to give them special treatment in bankruptcy. Some raise the illusory argument that without this special treatment, private student loans will become more expensive and less available. Allowing discharge in bankruptcy won't affect their availability, however, any more than, as Mr. Chairman noted, allowing the discharge of credit card debt and mortgage debt restricts the availability of those types of loans. The private student loan industry was expanding rapidly before the 2005 amendments. That expansion likely would have continued regardless. And even after giving them the additional protection in BAP-CEPA, we did not see expanded availability or a reduction in interest rates. This suggests that there will be minimal, if any, reduction in lending if the laws return to its pre-2005 status and private student loans become dischargeable once again. You've already dealt with businesses that are too big to fail. Let's not forget those who currently seem to be too small to help. NACPA and NCLC urge the subcommittee and the full Congress to repeal the preferential treatment extended to private student lenders in the 2005 amendments. Thank you very much.
Thank you, Mr. Weiss, and I want to compliment our panel, the first panel we've ever had to conclude on the red light. And I recognize myself now for 5 minutes of questioning. Professor Pardo, you mentioned a couple of possible legislative suggestions. One of them was to clarify, change, make constant in the definition of undue hardship, I believe, and the other was maybe to 86 on the undue hardship, get rid of it. Those are different solutions. Which do you think is preferable?
Well, based on what my studies have shown me, in an ideal world, if we could start from scratch, I would say that all student loans should be dischargeable in bankruptcy, but I realize we're not at that point today. It might be hard to unscramble the egg. So I propose two solutions. I think the ideal at this point is to undo the preferential treatment for private student loans and at the same time recognize the difficulties that other student loan debtors face in bankruptcy, those who borrow from the federal government or nonprofits, and the difficulties that they face in litigating their claims of undue hardship, and therefore clarify the standard. So really two proposals. If you're going to take the steps to get rid of private student loans, at the same time also introduce legislation that clarifies the undue hardship standard.
So you think we need to do both, clarify the undue hardship standard, and two?
Make private student loans automatically dischargeable.
If they're automatically dischargeable, where would you have the undue hardship rule?
The undue hardship rule would continue to apply for either
for the
loans made by the federal government or made by nonprofits or guaranteed by the federal government or guaranteed by nonprofits.
Okay. Okay. I liked your analogy there. I've heard about making sausage. I'd never heard about the scrambled egg, but now we got all of breakfast together here in Congress. Mr. Culbertson, I appreciated your Cuthbertson, I appreciated your testimony, and you have a different perspective. And I understand where you're coming from. And without assuming that your premise is something I concur in, the idea that somebody could mount up a lot of debt, not have gone into the income world, and discharge their debt, and then go on and earn their, great bonuses and whatever in the private world of life and income, doesn't seem equitable. Last year, Danny Davis's amendment was like only could discharge it after 5 years, I believe. Is there some time limit that you think might be agreeable to where we could get the minority to agree to us to make a good egg?
Well, I think the law used to contain a time limit in the 1990s, and it was gradually tightened over the years as part of the Clinton administration supported amendments that changed it from, it had been 5 years, and then it was changed to 7, and now taken out altogether. Sure, that's a possible solution that Congress would be, would be a reasonable exercise of Congress's powers.
Do you think reasonable exercise of Congress's powers is we can do a lot, wars and whatever, but neither here nor there. What do you think would be a reasonable solution to balance that? I mean, you're coming not representing a client, all of a sudden you're the czar.
Well, I think I would agree with Professor Pardo that if Congress is going to do anything, take any action in this area, that it should clarify the standards for undue hardship under the code. I think that's what would be most beneficial. If the concern is, a lack of uniformity across the circuits across the country, and the concern is that judges are applying their judicial discretion in a manner that's not uniform, then Congress could provide direction setting out the standards for undue hardship.
Have any or all of you, or which of you have submitted any proposed definition? Have any of you submitted that? No? You could all do that, though.
No, sure.
I've pointed in my written testimony to looking at the presumption that exists for undue hardship in the context of the approval of reaffirmation agreements in bankruptcy. So a reaffirmation agreement is when the debtor proposes to repay a debt that otherwise would have been discharged. If that agreement is to be approved and have legally binding effect, one of the things that must be shown is that it will not impose an undue hardship on the debtor. And with the 2005 amendments, Congress included a presumption that basically says if the debtor's disposable income is insufficient to repay the proposed payments in the agreement, there's a presumption of undue hardship, meaning the agreement will not be.
So you think that one flies?
I think that would help a lot in two ways. One is it would concentrate, again, the analysis of undue hardship on financial criteria, which I have found in my studies aren't driving outcomes. And really, if you look at both of those provisions, they ask, what's the effect of having to repay a loan?
I'm going to ask each of you, if you would, after the committee, to give me what you think is an appropriate legislative remedy on this definition. Ms. Asher, what do you think about Mr. Cuthbertson's suggestion that these folks can mount up this large debt, wipe it out, and then go on and get into some gecko world?
Well, I think Professor Pardo has already addressed the fact that there was no evidence of abuse of bankruptcy by student borrowers of either type before the bankruptcy law changed. So I wouldn't expect that to be any different. You have to meet very stringent criteria for bankruptcy, and if you borrowed something fraudulently, it's not eligible for discharge, even under regular discharge rules.
But you wouldn't have borrowed it fraudulently. You'd have borrowed it with all good intents, and then you graduated and said, hey, I can start clean.
bankruptcy and default are not exactly clean. They have very serious and long-term financial consequences. They can make it hard to get a job or rent an apartment or do any of the other things that you would need to do to enjoy the benefits of such unlikely behavior. But I'm not a bankruptcy lawyer, so I can say that in the industry, we've already seen, because of the credit crisis, a significant increase in credit standards and the requirement of cosigners for almost all private loans. While there was some contraction in the industry because of the credit crunch and some very highly leveraged lenders that were making, in many cases, some very high-risk loans, Sallie Mae, Wells Fargo, Citibank, and increasingly credit unions and now some schools are very much still in the private loan game. There was huge growth, as I think Professor Pardo noted, from 97 to 2005, the private loan industry volume grew by 800%. That was without the benefit of this special treatment in bankruptcy. The industry seems to have a lot of profit opportunity. Sallie Mae still projects that it's going to make a third of its profits or more from private loans. So I think that some of the concerns are either overblown or have already been addressed by a market correction.
Mr. Cuthbertson, are you familiar with Professor Pardo's study?
Yes, Chairman, I am.
Where do you find it, where do you question it?
Well, I guess I question the conclusion that Professor Pardo reaches, that because if you accept the premise that the undue hardship standard is not being applied uniformly by bankruptcy judges, that therefore we should just do away with the undue hardship standard and make private student loans automatically dischargeable. I think, as I said, I think if there's a problem with the application of the standard, Congress can give further direction on what the undue hardship standard should entail. I don't think it necessarily follows that you just scrap the undue hardship test altogether. I also would take exception, I think, with the significance placed on what Professor Pardo has called extra legal factors. Those being the experience level of debtors' counsel or creditors' counsel, bankruptcy judges' predispositions to certain issues. I think those things are part and parcel of our system of litigation, and that happens in every court. And there's nothing inherently wrong with that. That's the way that every individualized factual determination has to be made. And those factors come into play in all types of litigation.
What about his suggestion, and Ms. Asher seems to concur, that there was not a problem with student loans in the past and that there's only been a few exceptions that were highlighted to make it look like there was abuse?
Well, I guess I could only say that that was the stated purpose in 1976. And I don't have empirical data to support that there is a lack of abuse or not.
Thank you, sir.
I'd be happy to supplement the record.
Everybody has an opportunity to do it, and we'd be happy to have your remarks, as you'll find out later, to submit later and to amend it. Thank you. Now that I've taken over my 5 minutes and been a very poor example to the witnesses who did so good, I recognize my ranking member, Mr. Franks.
Well, thank you, Mr. Chairman. Mr. Cuthbertson, I suppose that in nearly every business endeavor where there is some type of contractual arrangement, and especially if it's a financial one, that the bankruptcy code tries to make a balance between trying to encourage people to pay their debts and to make it a hard route for them to simply discharge it, and yet to be able to have a pressure relief when it is simply the hardship exists and is simply not reasonable to press forward. Obviously, as someone who's been in business in the past, it occurs to me that those people who make the loans take that balance as probably one of their central elements of calculus when they decide whether to make a loan or not. And that being said, do you think that if the Congress clarified the undue hardship provision so that rather than changing, you've got private loans, you've got nonprofit loans, you've got federal loans, if we had that as a consistent definition in all of them, don't you think that that would be at least a better way to have a consistent lending practice, first of all?
Yes, I do, because the considerations that Congress has taken into account to make educational loans, non-dischargeable, apply equally to federal loans as private loans. They're both there to ensure access to higher education, and important public policy that Congress has deemed important, and to to make funds available for students to attain a post-secondary education. So whether it's a federal loan or a private loan, they're both serving an important public and societal good. So I do think that if you look at taking away non-dischargeability for private loans, you've still got the problems that are alleged with the application of the undue hardship standard for the federal loans. So I think that I agree with your assessment. Congress should look at, if it's going to do anything, making that standard clear for all loans.
Well, it occurs to me that if we make bankruptcy, the easier we make bankruptcy, it occurs to me that the more we will have bankruptcy, given that there's pressure on all of us to, to try to discharge our debts if there's an easy way to do it. Do you agree with that, just a kind of an affirmative or negative? Do you think that making bankruptcy, this will make bankruptcy easier if we pass legislation doing away with the discharge, the system as it is now? Do you think that this will make bankruptcy easier?
Yes.
And do you think that that will increase the incidence of bankruptcy?
It would increase the incidence of, yes, bankruptcy in particular, well, in general, and the petitions to discharge educational.
Right. Well, I think it's maybe it's just an old-fashioned perspective, but I think it's probably not a good thing for students to start out in life with the bankruptcy on their record, even just for their own intellectual standing. It just has a negative effect. And I do think that you're right, that this will increase bankruptcy, and that can't be a good goal. I don't think it is. Because if you increase bankruptcy, then you put greater costs on the system. That's inevitable, no matter how you face it. Somebody has to pay for that. Now, I know that some of our liberal friends, and I say friends, and I really do mean that. I know they don't like the word liberal, but some of our friends on the left here can't seem to understand that you don't have a free lunch. You just, if there's losses, that the system has to compensate for that. So if Congress amends the bankruptcy code to allow private student loans to be unconditionally discharged, will anyone other than private lenders have to bear the cost of this change in the law? In other words, will there be ancillary impact in other areas? Will this will this make it easier to gain student loans in the future?
No, I think I agree with what you said. Lenders do take loss expectations into account in pricing their loan products, and if there are greater than expected or anticipated losses, interest rates will go up, or the credit granting criteria will be tightened.
Wouldn't it be the most naive lender that would not take that into consideration? I mean, you'd flunk banking 101 if you didn't take your loss ratio into consideration. Yeah.
I don't know of any lender that wouldn't take that into consideration.
Well, I guess, Mr. Chairman, I won't belabor the point here, but I really am convinced that we could deal with the hardship issue effectively. I mean, I'm concerned that we might go one way or the other too far, but the idea of making bankruptcy an easy option, and I think this makes it easier, I think not only increases the incidence of bankruptcy, but in the long run it puts additional burdens on the system, which in the final analysis will mean less money available for student loans and more bankruptcy among our young people. And unfortunately, I wish there was an easier way to do all of this, but the market sometimes seems to have a wisdom that those of us in government just can't possess no matter how hard we try. And so with that, I'll yield back.
Thank you. Since I'm the only one here, no, I don't mean that. I just think that the reference in liberal and left, I don't know. I think liberal's better than left. I'm not sure, but I don't know where it was directed.
I don't know.
Yeah. Right, anyway, Mr. Coble, you're recognized from North Carolina.
I was to Mr. Price left.
I noticed that.
Good to have the panelists.
You have lots of ground over there, though.
Good to have the panelists with us. Mr. Culberson, maybe I'm missing something, but I want to extend partially to Mr. Price's line of questioning. What lender is going to make student loans if the borrower can file Chapter 7 the day after graduation and thereby fully discharge the debt, especially given that the means test, as I understand it, would be a non-issue for someone that is a borrower with no prior or very low levels of employment income. Wouldn't it be hard to find anyone coming forward to make a loan under those conditions?
I think that's certainly the concern amongst private sector, private loan lenders, yes.
And some of the testimony today is that private student loans are more akin to credit cards than to financial aid. What steps outside of bankruptcy can the Congress take to make private student loans more like federal student loans and less like credit cards? I'll start with you, Mr. Culberson.
I think, Ranking Member Franks mentioned in his opening remarks maybe a more comprehensive reform if there are abuses in the system, disclosure requirements, regulations that would extend benefit programs to private loans, those types of things would equalize the playing field, I think. And my way of thinking is that if you're going to do a bankruptcy reform, it's very limited. If there are true abuses in the system, then there are things that maybe Congress could do other than limiting it to taking away the discharge exception in bankruptcy.
Well, that was sort of my thinking. Professor, let me bring you in on this. If to extend the question somewhat, if private student lenders are in fact engaged in abusive or misleading lending practices, would we not be better in the Congress to regulate those practices than simply making private student loans dischargeable in bankruptcy?
Well, something has to happen. So the problem with the private student loans is that they don't really offer the same robust avenues for relief from financial distress outside of bankruptcy that federal loans do, for example, or government loans. So if you're not going to have those, you have to have some sort of social safety net. And currently, really the only safety net is bankruptcy, but it's hit or miss with how an undue hardship discharge proceeding comes out. So student loan borrowers who have private student loans who can only look to bankruptcy for relief are going to be in much more difficult situation than borrowers of federal government loans.
Mr. Chairman, and I say to the panelists, I am not without compassion, but I have some problems about just willy-nilly discharging debt. That sort of hangs in my craw, Mr. Chairman, and I'm not sure that I have any solution. Anybody else want to be heard on this?
With
Ms. Asher?
That just, I think, okay, no, it wasn't. That just isn't going to happen. It's not going to happen because the system as it is currently constituted would not allow a student immediately upon graduation, and as some of the apocryphal stories went, on the eve of being employed in a high-paying position, to go ahead and discharge their student loans. They're bad faith issues. And the judges I practiced before, and I suspect the judges that virtually all of my colleagues practiced before, would not allow a discharge to occur under those circumstances. Further, even if the 2005 Act is rolled back, we have the 7-year delay from the date that the loan first became due before it could be discharged in a Chapter 7.
Well, Mr. Weiss, how about the student who is not employed, does not have employment of a high-ranking firm?
Well, again, if we go back to the previous law, they would not be able to file immediately upon graduation. And I believe one of the reasons why that time period was imposed was to prevent exactly the type of situation that you're referring to. I don't think anyone at this table, any of the bankruptcy practitioners nationally, would believe that it would be appropriate for a student, absent extraordinary circumstances, severe illness, incapacity, etc., to be relieved from their obligation to repay their student loans immediately upon graduation.
Well, let me thank you, Mr. White. Let me bring Ms. Asher in before my red light illuminates.
I think it's important to, in addition to the fact that
It just illuminated, but I guess the chairman will go along with us.
Students are actively pursued by credit card companies, even though that debt is dischargeable in bankruptcy. I think, again, I'm not a bankruptcy lawyer, but automatically dischargeable is not really how things work. You still have to prove that you can't afford to pay off your particular debts, and they're subject to some considerable review within the regular bankruptcy process, even without the added standard of undue hardship. But more importantly, there are such major distinctions between private loans as a product, a financial product, and federal loans that we need to look at them in the context of how we treat other kinds of debt, like credit card debt, like even in extreme cases gambling debt, in thinking about how people approach bankruptcy. Certainly credit card companies have continued to pursue these very same kinds of students based on assumptions of future earnings, even without being treated in this unique way that private loan companies are. And in fact, it has taken an act of Congress to help constrain some of the most extreme and abusive marketing practices. I'd say in this context, there may be things that Congress should consider broadly beyond this jurisdiction to rein in some of the most abusive and consumer unfriendly practices in the private loan industry. Nevertheless, borrowers of all kinds of debt are in need of that ultimate relief of bankruptcy should they reach those extreme financial circumstances where it is their only alternative.
Thank you, Mr. Coble, who comes from one of the highest, probably, expenses of the public plan in education, University of North Carolina. Great school, good public plan. Professor Pardo, tell me a little more about your study. Did it go into the issues of whether or not a lot of students, when they graduated, used bankruptcy to wipe out this debt?
Well, I'll cite two statistics. One, the median age of the debtor in my study was 42 years old. The average age was 45 years old. These are not people who are recent graduates on the eve of lucrative careers who have a lifetime of employment ahead of them. These are folks who have been trying to make a go of it for a long time, and they just can't make ends meet, and they're under crushing debt burdens, and so they look to the bankruptcy forum as their avenue for relief.
Well, I'm saying, but before the undue hardship rules, 2005 for the private world, and maybe I guess it was 1976 for the, was there some large number of folks using the bankruptcy system?
This very Congress commissioned a GAO report to delay the effective date of the provision that would make student loans conditionally dischargeable, so it could see what had been happening in bankruptcy when they were automatically dischargeable. And the GAO report commissioned by this Congress found that less than 1% of all federally matured student loans were discharged in bankruptcy.
And,
so
that covered what year or years?
1975 and 1976.
Okay, and how about, and those were federal loans?
Yes.
Was there a study on private loans? Was that not an issue?
It wasn't an issue in the private.
They didn't have the undue hardship rule at the time.
There wasn't the undue hardship rule, but the private student loan market really was not at the point it is today.
Well, prior to 2005, when the private loans were, then the undue hardship rules applied there. Prior to that, were there a lot of private loans that were being bankrupted?
I don't know the answer to that.
Does anybody know the answer to that?
I don't know the answer, but I think that there probably weren't. I would suspect there weren't because the private loans and the private sector private loans have really taken off in response to the rapidly increasing cost of college education and the caps on the federal programs. So they don't, federal program loans do not cover the entire cost of college education in most instances.
Well, 2 weeks ago, and I don't know if this is really necessarily on point, I think it is so, we had an economist named Joseph Mason, and he testified before this subcommittee that by making the discharge of debt and bankruptcy more difficult, the bankruptcy, BABCISA, 2005 emboldened leaders to act recklessly in their lending practices, ultimately leading to the onset of the home foreclosure crisis. And he suggested possibly there was some similarity in what might be going on in private student loans. Do you think that, do you have any reason to believe he's wrong?
I can't really speak to that issue. I don't have any reason to believe he's right or wrong. Chairman,
okay.
I don't have any information.
Ms. Astor, do you have any thoughts on that?
Yes, I do.
Surprise, surprise.
In 1997, the National Bankruptcy Review Commission, which was a bipartisan commission founded by Congress, determined that there was no evidence to support the assertion that students systematically abused dischargeability in bankruptcy. As to your question about, forgive me, I've just forgotten the second part of the question. Did lenders make riskier loans after 2005? There is some evidence that the answer is yes. Sallie Mae dramatically increased its portfolio of non-traditional subprime loans during that time, as I mentioned in my oral testimony, is also spelled out in my written testimony, finding, not surprisingly, that these very, very high-risk loans turned out to have very high default rates, and then got out of that business in 2008 when there was less access to easy credit and to the securitizations that allowed lenders throughout the economy to make loans to people who they knew couldn't afford them, often under false pretenses, and walk away without having to respond to the risk because they've been sold down the chain.
You mentioned in your testimony, or maybe in response to a question, something about the cosigners. Let's just say you get these private loans, and they can be discharged, or federal loans for that matter, but private loans in particular, and they've got a cosigner. Are most of them requiring cosigners now?
Virtually all require cosigners.
And the cosigners, they don't get out in bankruptcy, do they?
They're completely on the hook.
So then, how does if the student can go ahead and get out of their debt to the lender, which is what Mr. Franks fears would happen, but the lender still gets their money because they've got this solvent cosigner. Mr. Franks should be happy because the lender's still making money and they've got this cosigner on the hook, and the cosigner can always go after. Well, the cosigner might not be. They couldn't go after the debtor, or could they later on?
The cosigner is subject to all the same conditions of the contract as the primary signer, and that includes no discharge in the case of death or disability. I know that someone that we work with a lot, Deanne Lunan, who wasn't able to be here today, has a client, a parent, who has a child that had a permanent brain injury, and that loan is not dischargeable even under that circumstance, while the student's federal loans were. Another instance where the parents co-signed, actually I think in this case it might have been a spouse, and the primary borrower died before he could finish his education. Again, absolutely no relief. And unfortunately, because of the way these loan contracts are structured, very differently from federal loans, the borrowers are really at the complete mercy of the private lender in trying to negotiate any kind of accommodation. And when bankruptcy is the only possible relief left, they are left with this very arbitrary and onerous process, which is not based on the merits of their case.
Mr. Cuthbertson, what about that? When you get a cosigner, doesn't that kind of give the lender some solace?
Yes, Chairman, I believe it does, and that's probably why they are requiring cosigners, because that makes that makes the borrower the repayment of the loan more likely.
Even if the borrower can bankrupt it.
Well, yes, because then you have a cosigner who.
So then isn't this all kind of semi-academic, except for the fact that the college student's going to be left on the hook, and they're going to, if they want to go bankrupt, then they can only go bankrupt for 7. They got this time limit. They can't do it again. They got it on their record. They got trouble renting an apartment, getting a job, whatever, unless they work for their parents, in which case they got an apartment and they got a job. The borrower's not out at all.
Well, the co-obligor or the cosigner, I think the issue there would come down to how would that present an undue hardship on the cosigner, and that it would be dischargeable or non-dischargeable in bankruptcy to the same extent as it would be by the student.
Right. But don't you think, like, the cosigner's not going to be, maybe I'm missing something here, the cosigner's not going to be discharged in that bankruptcy?
Not without showing an undue hardship.
And the borrower just has to get a cosigner that's got some capital, some reserves, which I presume they do anyway. So in reality, there's not going to be a problem. They're going to get a cosigner that's several years older, already making money, got an income stream, got some real property that they can attach, and they're going to be happy.
Well, assuming they can do that, I mean, most students who are applying for college loans are 18 and are.
Yeah, but they're not getting their girlfriend to sign or their boyfriend. I mean, they're getting some older type that's willing to help them get through life.
Right.
Mr. Weiss, is this kind of maybe, isn't the cosigner the answer to the problem?
Oh, yes and no. You're absolutely correct that if the borrower files for bankruptcy and is discharged, then the lender can go after the guarantors. And, when my daughter applied for a student loan, they needed a guarantor, and, that was me. So I'm very familiar with that process. One issue that has been spoken about is that people would view bankruptcy as an easy option and sort of willy-nilly, oh, what the heck, I'll go ahead file for bankruptcy. That is so far from reality, with due respect, that it is just absolutely dead wrong. The people who come to see me to file for bankruptcy would rather have a root canal without anesthesia than talk to a bankruptcy lawyer. They are embarrassed, they are ashamed, they have been trying for years to live up to their obligations and pay their bills. And they only come to see me when they are completely incapable of doing that. Student loans are not the primary factor for bankruptcy filing. Student loans are sort of in the mix for a client who's been ill or had job loss or their business went down the tubes, largely due to factors outside of their control. People very, very rarely, and the data justifies this, file for bankruptcy because of a student loan. It is merely one debt that is in the mix.
I'd like to yield to your ranking member, who maybe has seen the red light.
Thank you, Mr. Chairman.
The light.
Ostensibly, when we began this hearing, this was about, at least to some degree, how to make it easier on students. In other words, we were trying to assist students here, and even though I made the case the best I could that I believe in the long run this will hurt a larger number of students, it might help some in a challenging situation now, but I think it'll be to the detriment of the larger number of students. That's my personal opinion. But now I hear about the co-signers here. It sounds like we're all of a sudden now encouraging an entirely new class of people to take bankruptcy. And I'm not sure that that's good for the system either. If we make it, the easier we make bankruptcy, I agree with Mr. Cuthbertson's statement, the easier that we make bankruptcy, and again, you can ask whether it's the right thing or not, but the easier we make it, I think the more we increase the chances of the loans not being paid back. And if we increase the default rate, if we increase loans not being paid back, that money has to go somewhere. I mean, it has to come from somewhere. And I believe that that will decrease the available amount of capital for loans. Now, we talked about credit cards. Sometimes maybe somebody that takes out bankruptcy credit cards might have maybe 4 or 5 credit cards, $5,000, $6,000 a piece, because there's a certain cap on credit card lending. But as Mr. Weiss pointed out, some of the college education is now around $200,000. Well, that's not far from the median price of a house. And if we expect people to make these high-risk loans of up to $100,000 or $200,000 for a very good purpose, which is to help our young people get education, but if we expect the money to be there for them, if that is our purpose, then the more we weaken the system by which they can make some type of common sense calculation, or at least have some confidence that they're going to be repaid, the less they're going to do that. It's that fundamentally simple. I wish it weren't. I wish there was some way to turn lead into gold. I really do. But unfortunately, reality will prevail in this situation, as it always has. You mentioned, Ms. Asher, related to would you call it the Sallie Mae, where a lot of the loans that were made were not really very sound loans. Well, now, there was an awful lot of pressure on people to make loans that weren't sound. And did that help the people who got the loans? Probably not. Didn't help them much because those loans weren't sound and they ended up getting in trouble anyway. And did that hurt everybody else? Yeah, I think it did. If you apply it to the mortgage industry, it was the central element of the entire economic meltdown. It's okay to blame Wall Street for some of the bad things they did. They did a lot of bad things, but they essentially took loans that were rated a certain way and repackaged them and sold them off, and I think there's some big problems with that. But they took these loans and they repackaged them. If the loans had performed as those who rated the loans said they would, all of the problems could have fundamentally been eradicated. It wouldn't have been a meltdown if the loans had performed, but they didn't. And I think that we have to realize that there's about 3 or 4 factors that give us the best chance of seeing loans perform. One is people have to be able to make a calculation saying, okay, this person, they don't have a job right now or whatever, they have to make a calculation on the person's ability to repay the loan with co-signers' help or not. Secondly, they have to make a calculation whether or not the loan can be profitable to them to make it at a certain interest rate. And all of these calculations have to be in place before they make the loan, before any of it happens. And if we tinker with the bankruptcy code in ways that will weaken that system, I know there's a balance, but if we tinker it with ways that will weaken the system, I think we will hurt students in the long run. And fundamentally, I'm hoping, and I'm going to let this be my last word to the chairman, I'm hoping that we can do something to define undue hardship in a way that is in comportment with both our values and with common mathematical sense that a businessman or a business individual can make an empirical calculation on so that they can make these loans. I think we'll be hurting the student loan program in the long run, or allowing government, or forcing government as it were, to supplant that, which in the long run, the way things are going, someday won't be there, and there will be a day of reckoning that will hurt an awful lot of people in a big way. And I think we'll all be the worse for it. And that example has been repeated throughout history. The highway of history is littered with the wreckage of systems that thought government could come in and run it better than the private market based on common sense principles. And with that, Mr. Chairman, I yield right at the light.
Thank you, Ranking Member. We appreciate your apocalyptical analysis.
Never heard that word.
Yeah, well, I might have made that one up. I don't know. The apocalypse, apocalyptical. That's it. I left out a consonant. But I appreciate all the testimony, and we appreciate Chairman George Miller, who couldn't be with us today, endorses the hearings and thanked us for having these hearings and thinks it's important that we get into this issue. We're going to look into doing some legislation. As I said, I appreciate each of the members here submitting to us how they think we can define undue hardship to make it a level playing field in all the jurisdictions, and also any other suggestions they've got for legislation.
Mr. Chairman, with your permission, I'd like to put this statement for the record, Education and Finance Council on the record, September 23rd, 2009.
Without objection.
Thank you, sir.
So done. So with that, I'd like to thank all the witnesses for their testimony today. Without objection, members will have 5 legislative days to submit any additional written questions, which will forward to the witnesses and ask you to answer them as promptly as possible. Be made part of the record. Without objection, the record will remain open for 5 legislative days for the submission of any other.
Line, Julius. She's pretty.